Did the court strike down Trump's tariffs or just refuse to apply the law? Let's find out. Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. Today's lecture, ladies and gentlemen, we're going to be discussing a very hot button topic issue that is certainly making its way through the news media rounds, that of course being the recent opinion published by the U.S. Supreme Court that supposedly strikes down Trump's tariffs. Now, of course, as always, we're going to be reading through the opinion, we're going to be reading through the actual law that's being referenced, and then we're going to apply, again, as always, the U.S. Constitution and figure out whether the court upheld the Constitution, upheld the law, if Trump's in the wrong, if he's in the right, if he's exercising powers he can exercise, or if he is exercising powers outside the scope of Article 2 in the U.S. Constitution. Frankly, we're just going to come down to the solution of what exactly the U.S. Constitution actually provides and whether or not the U.S. Supreme Court applied those provisions. So let's go ahead and jump on over to the publication, to the opinion. The question that the court said they are being presented, is whether the International Emergency Economic Powers Act, IEEPA, authorizes the president to impose tariffs. So let's go ahead and answer this question before we actually read through the opinion, because the arguments that they use to try to circumvent what the legislation, I'm not going to call it a law, the legislation actually says. So here is the International Emergency Economic Powers Act. I think it was enacted in the 1970s. The important, pertinent part is down here in Section 202 and 203. So it says here, Title II, this is where it's actually allocating the powers to the president. It says, any authority granted to the president by Section 203, this part I have highlighted down here, may be exercised to deal with any unusual and extraordinary threat which has its source in whole or substantial part outside the United States to the national security, foreign policy, or economy of the United States, if the president declares a national emergency with respect to such threat. Here is just one. He's given a few outlined down here, but really this first one venerates the actions of the Trump administration with regard to the tariffs. Section 203A1. At the times and to the extent specified in Section 202, so the parameters here, unusual and extraordinary threat, the president may, under such regulations as he may prescribe by means of instructions, licenses, or otherwise, very encompassing, investigate, regulate, so now dissolving the free market, the government, specifically the president, getting intimately involved in the transaction between whom? Investigate, regulate, or prohibit, one, any transactions in foreign exchange. What is included with regulation, ladies and gentlemen? A tariff, a surcharge, to make it more difficult, to make it more expensive, to make it more costly for a foreign nation to either import or to, well, I guess import would be the sole topic, but to make it more costly for a foreign nation to import any sort of their goods. That is absolutely encompassed, even if the court doesn't like it, in these legalistic terms, in this ambiguous legalese. Otherwise, regulate any transactions in foreign exchange. So now let's see what the court has to say. Let's see how they try to circumvent this. So here is their direct opinion, the first publication of the page. We decide whether the International Emergency Economic Powers Act authorizes the president to impose tariffs. We scroll down further. They talk and discuss about how when Trump came into office, he wanted to address two main threats. The first one being the drugs being swarmed in or flooded in to the states, and the other one being, I think, what was it? We have it up here. I didn't highlight it. Shortly after taking office, sought to address two foreign threats. The first was the influx of illegal drugs from Canada, Mexico, and China, President proclamation, so on and so forth. The second one was large and persistent trade deficits. The IEEPA, with otherwise regulate any foreign exchange, absolutely grants that power to the president. The court says here we have long expressed reluctance to read into ambiguous statutory text extraordinary delegations of Congress's powers. That is absolute bogus. There is a standing opinion from the U.S. Supreme Court that they could overturn, that they could roll back. They've already had a couple chances to roll back, where they redefine in totality the term regulate and commerce. That's been standing since, what was it, the 1870s? Or was it the 1890s? We just recently went over the case. We have long expressed reluctance to read into ambiguous statutory text. Absolutely bogus. They're lying. Further, the text actually isn't ambiguous. There is no confusion. It gives the president very encompassing powers. He can do this, regulate, impose regulations via instructions, licenses, or otherwise. Very encompassing. He can investigate, regulate, very encompassing, just as the SCOTUS is always upheld, with the necessary and proper and the commerce clause. Absolutely grants the president to exercise tariffs, to impose tariffs. They go on further and further, talking about how the president has been imposing unequal, segmented, distinct tariffs on different places, and that's unjust. That's not unjust, but not within the scope of the IEEPA. Ultimately, they come to the conclusion the judgment of the United States Court of Appeals for the Federal Circuit in case number 25-250 is affirmed. The judgment of the United States District Court for the District of Columbia in case number 24-1287 is vacated and the case is remanded with instructions to dismiss for lack of jurisdiction. Completely unbinding. So here we have Gorsuch, who gives a very funny rebuttal. He says, the president claims that Congress delegated to him an extraordinary power, not just one, multiple, in the International Emergency Economic Powers Act, IEEPA. Extraordinary? Doesn't really matter. Encompassing? Yes, in the IEEPA. The power to impose tariffs on practically any products he wants from any countries he chooses in any amounts he selects. At the times, and to the extent specified in Section 202, the President may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, such as tariffs, regulate, such as tariffs, or prohibit any transactions in foreign exchange. You may not like it, Gorsuch. You may not like it, Neil, but the IEEPA absolutely grants a basic carte blanche permission slip to the president. The power to impose tariffs on practically any products he wants from any countries he chooses in any amounts he selects. It absolutely does. He goes on to say, whatever else might be said about Congress's work in IEEPA, it did not clearly surrender to the president the sweeping tariff power he seeks to wield. Sure. However, such as the Act provides, whenever he sees fit, extraordinary circumstances, extraordinary threat, national emergency, unusual, the typical legal ambiguity, that the typical legalese that the U.S. Supreme Court itself would use when trying to extrapolate a statute or constitutional provision to its liking, absolutely does provide not a sweeping power for tariffs, but whenever the president sees fit that there's a supposed national threat, he can absolutely, according to this act, by means of instructions, license, or otherwise, such as a tariff, regulate any transactions in foreign exchange. We go further down. Gorsuch actually addresses the critics, not the critics of the tariffs, but the critics of the doctrine he's appealing to. He's appealing to the grand question, I think is what it's called. Oh, did I not highlight it? Let's see, applying the constitutional lodges under the doctrine's terms. Goodness me. There it is, major questions doctrine. Applying the major questions doctrine. And what that doctrine says is anytime there is an extraordinary event and the president is going to exercise extraordinary powers, he has to be able to provide a direct citation to a statute which provides or which shows and demonstrates that he is in fact allotted that authority, that he is allotted that power. So he tries to make the argument that even though there are critics to this doctrine, they've actually upheld it a time or two. Whatever else might be said. Oh, wait, we've already gone over that. Oh no, did I lose the quote? There it is. Okay. Start with the critics of the major question doctrine. In the past, they have criticized the major questions doctrine. If I'd have just kept reading on. For two main reasons, the doctrine they have suggested is a novelty without basis in law. Sure, because if a statute does not grant the president the authority, the president shouldn't be exercising the authority in the first place. So it's a prerequisite, it's not a better to do it and apologize than to wait for the go-ahead to go ahead and act. That's never how the U.S. Constitution is. It was never understood that way as a apologize later. It was a restraint on the government so that way it doesn't act. So now we get on to Justice Barrett, who concurs with Gorsuch, but not in totality. Again, she brings up the major question doctrine and disagrees with it. She says, as the principal opinion demonstrates, the most natural reading of the International Emergency Economic Powers Act does not encompass the power to impose tariffs. Why not? Why not, Amy? Because when I come back here and I read over this, the president may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, investigate, regulate, or prohibit any transactions in foreign exchange. How can you regulate? What's one way a president can regulate? What's one way anybody can regulate commerce and exchange? By making something more expensive to produce. How does the president do something like that? Or not even just produce, but to sell. How does a president do something like that? By imposing a tariff. Or otherwise. Very vague, very encompassing. Regulate. Very vague, very encompassing. Any transactions in foreign exchange. Very vague, very encompassing. So you may not like it, Ms. Barrett, but the IEEPA absolutely does grant the power of tariff to the president. Now we get on to Justice Kagan and her consent or her concurrence with Sotomayor and Jackson. She states, the court holds today that the International Emergency Economic Powers Act does not authorize the president to impose tariffs. It absolutely does. I agree with that conclusion. Neat. As I do with the bulk of the principal opinions reasoning. So this is another part. They virtually all disagree with Gorsuch bringing up the major question doctrine. But because I think the ordinary tools of statutory interpretation amply support today's result, I do not join the part of that opinion invoking the so-called major questions doctrine. Let's reread over that last sentence. But because I think the ordinary tools of statutory interpretation amply support today's results. Really, Justice Kagan. At the times and to the extent specified, she must have some really cool glasses or goggles that is just totally reverting and reshaping how the statute is actually written and read. Because it says the president may, under such regulations as he may, I'm going to beat this dead horse all the way to the end because they wrote a 170-page opinion on something very clear. And they could have written a 5-page opinion that would have gotten the same result, but with actual constitutional backing. The president may, under such regulations as he may prescribe by means of instructions, licenses, or otherwise, investigate, regulate, or prohibit any transactions in foreign exchange. That's on page 3. It's only 8 pages. That's on the 3rd page. This very encompassing, very broad power absolutely does not support the finding of the court. So if we actually apply the ordinary tools of statutory interpretation, even if you apply the historical context of it, even if you apply it when it was, even if you apply what the legislators may have been thinking at the time that they were voting to implement this act, it still venerates the actions of the Trump administration. Here's Jackson giving her own opinion. She says, while probing Congress's intent is the right inquiry, my colleagues speculate needlessly. In my view, the court can and should consult a statute's legislative history to determine what Congress actually intended the statute to do. Really, I don't know how many times you've actually held that position. Is it just certain statutes that the history of the statute should be consulted, or is it only when it's going to benefit your political beliefs, the political beliefs that you were taught by the American Bar Association? Because very frequently, Or I'll go to the inverse. Very rarely do I ever actually see the SCOTUS consider the historical standing, the historical surrounding of any piece of legislation. Prime example, the individual income tax. The U.S. Supreme Court in modern times has upheld it when the U.S. Supreme Court, closer to the time that it was implemented, twice ruled that it was unconstitutional. So what changed? The U.S. Constitution hasn't been amended to allow something like individual income tax, yet this probing has never been respected. It's not respected by the U.S. Supreme Court today. And illegitimate acts stand because legislative histories of statutes aren't considered. So why is it, Miss Jackson, that this one's history must be considered, but not the others? She actually, I think, gave the shortest response, so that's appreciated. The shortest response of the dissenters, but she still played some lawyer trapeze, or I'll say attorney trapeze, to get around applying the law. And again, they could have written, instead of 170 pages, they could have written a 5-page response that would have gotten the same result, and probably even gotten the support of Justices Thomas, Alito, and Kavanaugh. So here's Justice Thomas, dissenting. He says, I join Justice Kavanaugh's principal dissent in full. I didn't skip over Kavanaugh's dissent, did I? No. Justice Thomas says he joins Justice Kavanaugh's principal dissent in full. As he explains, the court's decision today cannot be justified as a matter of statutory interpretation. Exactly correct. Congress authorized the president to regulate importation. Yes. Not just importation. Any transactions in foreign exchange. Any. Throughout American history, the authority to regulate importation has been understood to include the authority to impose duties on imports. You don't even have to go that far. As always, go ahead and read through this entire opinion, both the dissenting and the opinions in concurrence with the baseless ruling by the SCOTUS. Now here's Justice Kavanaugh's principal dissent, with whom Justice Thomas and Justice Alito join. He states, acting pursuant to his statutory authority to regulate importation under the 1977, yes, that's Nixon. Oh, I may be misremembering. Under the 1977 International Emergency Economic Powers Act, or IEEPA, the president has imposed tariffs on imports of foreign goods from various countries. The tariffs have generated vigorous policy debates. Those policy debates are not for the federal judiciary to resolve. Precisely. The sole legal question here is whether under IEEPA, tariffs are a means to regulate importation. In terms of the legislation, yes. Even when you consider the historical backing, the other justices or the other judges, the other actors on the court, tried to say that if you apply the historical backing, you're going to clearly see that the tariff power is still reserved to the Congress and not granted to the president. Actually not true. Point being, if you read the statute in the simple terms, or the simple statutory interpretation that Justice Kagan referenced, or it may have been Sotomayor, one of the actors, even if you apply that, the IEEPA very clearly, very broadly grants this power to the president. So after a very long dissent from Justice Kavanaugh, we come to this conclusion at the very bottom, in which he says, and concurred with by, and accompanied by, I should say, Justice Thomas and Alito, he says the tariffs at issue here may or may not be wise policy, but as a matter of text, history, and precedent, they are clearly lawful. I respectfully dissent. And I think there is a key word there they intentionally used instead of another key word that would have required them to side with the other 6, I'm not sure what to call them, activists and gowns on the court. It's just a mouthful. We'll grant them, well, I don't want to grant them the respect. We'll just say actors on the court. The tariffs at issue here may or may not be wise policy, but as a matter of text, history, and precedent, they are clearly lawful. I respectfully dissent. So one last time, I know we've beaten the dead horse so many times. Let's make it just one last time, and then we're going to go to the U.S. Constitution and show how both sides are incorrect. So section 203, A1, at the times and to the extent specified in section 202, so extraordinary and unusual threat, Those are the circumstances. Under such regulations, the president may, under such regulations as he, that's unilateral, singular, not plural, he doesn't have to confer with Congress, as he may prescribe by means of instructions, licenses, or otherwise very broad, very, very encompassing. A, investigate or regulate or prohibit. 1, any transactions in foreign exchange, the importing or exporting of currency or securities. And that's just one of a few powers that he is granted. That one, first and foremost, venerates the tariffs that the Trump administration has been imposing. Now, the key word that I pointed out here, which if changed would have required these 3 justices to side with the other 6, is lawful. Is every law going to be constitutional? No. Is everything that is lawful also constitutional? No. That's why Article 6 in the U.S. Constitution exists. So, let's go to the U.S. Constitution in Article 2. Article 2 defines and determines the executive branch, its powers, the qualifications to become the executive, tenure, everything of the sort. Specifically, Article 2, Section 2 lists the powers of the president. Let's go ahead and read over them. Section 2, the President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may, by law, vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. In Section 3, just to show, Section 2 is the only one outlining powers. Section 3, he shall from time to time give to the Congress information of the State of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Where at all is it even remotely implied that the president unilaterally gets to, 1, create any sort of tariff, and 2, enforce and exercise it? Nowhere. Not even remotely. Not even implied. If the U.S. Supreme Court justices would have just done that, and they could have done that in 5 to 10 pages, just say, no, actually the IEEPA is unconstitutional because the Congress is trying to give the president powers that Article 2 does not allow him to have. Congress has to first amend the U.S. Constitution, specifically Article 2, before the IEEPA can be implemented, can be upheld as any sort of legitimate law. Real quickly, let's go to Article 1, Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. There isn't the slightest implication that the president, either in Article 2, can create and exercise tariffs, or that Article 1, Section 8 allows Congress to give the president such a power. So what does that mean? That means via Article 5 of the U.S. Constitution, the U.S. Constitution has to be amended. Whether that be Article 1, Section 8 saying Congress can actually give these powers to the president, or Article 2 giving through amendment of the president's powers the authority to impose, to create and then impose those tariffs. That's all the justices had to do. That's it. And of course, we could dive further into the Federalist Papers and the Anti-Federalist Papers, where Madison and Hamilton thoroughly explained the role of the president. But you don't even have to go that far. I noticed a couple citations to the Federalist Papers from the actors on the Supreme Court. You don't even have to go that far. Why not just apply the U.S. Constitution, which you're actually told to do by Hamilton in Federalist Paper 78? Why did you go on this extravagant explanation trying to circumvent what the statute says? So the way both sides get it incorrect, well, in principle they get it incorrect, but in theory, the dissenting justices got it correct because they said the actions are lawful. They didn't say the actions are constitutional. Where the 6 actors get it incorrect is by their attempt to say that the statute doesn't provide for the authority. It absolutely does. It absolutely allows the president a very vague and broad authority to regulate any foreign exchange, which would include importation. How is that done? With tariff. Or it said regulations, licenses, or otherwise. Otherwise would include tariff. Regulate includes tariff. Making things more expensive, more difficult to produce and sell, that's regulation. That's what a tariff does. Any foreign exchange. Very broad, very encompassing. That's where the 6 actors just completely refuse to acknowledge the actual, the self-evident quality of the IEEPA. Where the 3 dissenting justices get it incorrect on principle, though not on technicality, is that the IEEPA is in and of itself unconstitutional, because neither does Article 2 grant the president the powers that the IEEPA tries to grant him, and Article 1, Section 8 does not allow Congress to go and give the president those powers. So the U.S. Constitution, either in Article 1, Section 8 or in Article 2, has to be amended before the IEEPA can be upheld. So what does this mean? Where does this put us in terms of the legitimacy of the Trump administration's actions? Well, first, it means the SCOTUS, I'm sure we all know, is full of hypocrites, is full of unprincipled, of unlearned individuals who only apply certain aspects of laws whenever it benefits their personal rulings. And it means that the understanding that is held or regarded as legitimate for the president and his powers is leaps and bounds very far separated from the powers enumerated in the U.S. Constitution explicitly, and of course further articulated in the primary sources of the founders in things like the Federalist Papers, the Anti-Federalist Papers, and the orations, the Philadelphia Convention debate transcripts, so on, so forth. Very short summary. The 6 actors got it completely wrong because the statute absolutely does allow the president to exercise tariffs. The dissenting justices got it wrong in principle because the U.S. Constitution does not allow the president at all in Article 2 or in Article 1, Section 8 to exercise anything akin to a tariff. In totality, the actors on the Supreme Court are either acting maliciously or incompetently, and the president is absolutely exercising authorities and powers far outside the scope granted to him in Article 2. Excellent. So if you have any questions, I know I was stumbling over my thoughts, kind of tongue-tied there at the end. If you have any questions about what I said, if you have any questions about exactly what the ruling provides for, about what the U.S. Constitution provides for, maybe you'd like those receipts I alluded to in the Federalist Papers and the primary sources, I'd be more than happy to provide those to you. Likewise, if there's a legal topic, I'm still tongue-tied, legal topic you'd like me to cover in a future lecture, go ahead and post those in the comments as well, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and until I see y'all in the next lecture, the next topic, I bid you all farewell.